You can go ahead and go for it, Andy. We are live now.
Okay. Welcome, everyone. We're going to give everybody just another minute or so to make sure that you join us, but we really appreciate those of you who've taken your time to join us for what should be a fascinating pair of panels today. All right. Well, I don't want to waste any more of anyone's time, so we're going to get moving now. Again, I want to welcome you formally. My name is Andrew Siegel. Many of you know me. I'm a professor of constitutional law here, former vice dean, the director of our Supreme Court initiative, and the primary organizer of this event. You've arrived at one of our signature events, our fourth annual Rapid Response Seminar. Every year, we pick a case that we think will be of significant interest to large swaths of academia, practitioners, and the public. And then we convene a panel of experts, lawyers, and academics to talk about that case. We get prepared early, but we wait for the decision to come down. And we come talk to you as early as possible, which is the next business day after the Supreme Court has issued its opinion. We've had interesting events over the last few years on affirmative action, on presidential immunity, on universal injunctions and birthright citizenship. And today we're convening to talk about the Supreme Court's decision yesterday in West Virginia versus B.J. I got that wrong. The very important cases involving the rights of transgender students in interscholastic athletics. Again, I want to thank you for joining us on behalf of Dean Verona, on behalf of my many colleagues who've worked hard for this event. We look forward to the discourse. We've got a great group. We've got two panels coming up. I'm going to give you just a couple of sentences on the decision and then kick you over to my colleague, Kelly Rodriguez, who is going to moderate the first panel, and I will moderate the second. As many, probably most, maybe all of you know, the Supreme Court had two cases that they were thinking about yesterday that they resolved in a single opinion. The question was whether state policies that prohibited transgender girls from participating on women's sports teams, whether those policies violated either Title IX or the Equal Protection Clause of the Constitution. As most of you probably know, the court, with varied reasonings, decided 9-0 that it was not a violation of Title IX, but they split very strongly and very contentiously on the equal protection issue. The majority of the court, in an opinion by Justice Kavanaugh, with several concurrences, said that there was not an equal protection problem with these policies. Justice Sotomayor dissented for herself and her two traditional liberal colleagues, arguing that indeed there was a problem, that the young women were entitled to a lot more process, were entitled to a trial or hearing on the facts, and the state had much more of a burden than the court decided. In reaching its conclusion, the court said that these classifications, these rules, were gender classifications, and said they were applying intermediate scrutiny, applied it in some interesting and controversial ways, and we'll talk about whether it's consistent with precedents. The court also did not decide whether, the court also denied that this was a classification on the basis of transgender status, but said even if it were, we don't have to decide what level of scrutiny to apply, because even if we applied intermediate scrutiny, see the earlier part of the opinion, this law passes intermediate scrutiny. I've got a lot more flags and notes on the opinion and things I want to share, but that's not my place. I've gathered experts to do that work for us, and I'm going to kick it over to Kelly to start us off with the first panel. Thank you all again for joining us.
Thank you so much, Professor Siegel, for introducing today's event and framing our discussion today. My name is Kelly Rodriguez. I am Assistant Dean here at Seattle University School of Law, Assistant Dean for Academic Affairs, and I'm Director of our Sports Law program. My research is in and around student athlete experience and Title IX. Really excited to have a really fantastic group of scholars and practitioners today from across the country. We're limited on time, and I want to make sure that they are able to share all of their thoughts. So my introductions won't fully capture the expertise we have, but hopefully we will get through a lot of the high points and leave some time for questions. Joining us today, we have Brian Sutherland, a partner at Beal, Sutherland, Berlin, and Brown. Brian is a nationally recognized civil rights attorney, best known as lead counsel in Bostock versus Clayton County, the landmark Supreme Court decision securing nationwide protections against workplace discrimination based on sexual orientation and gender identity. As a fellow graduate of Seattle University School of Law, we are especially happy to have you here. Thank you. We are also joined by Michael Dorff, the Robert S. Stevens Professor of Law at Cornell Law School, and one of the nation's leading constitutional law scholars. A former clerk to Justice Anthony Kennedy, Professor Dorff is the author of numerous books and more than 100 scholarly articles on constitutional law and the courts. Next, we have Nuzun Menka, Assistant Professor of Law and Faculty Director of the Northwest Center for Indigenous Law, right here at Seattle University School of Law. Professor Menka's teaching and research focuses on Indigenous peoples, constitutional law, environmental law, and the self-determination of Native nations. We are also pleased to welcome Jennifer Levi, who hasn't yet, but might join us, running into a little bit of logistical challenges. Jennifer is Senior Director of Transgender and Queer Rights at GLAD Law for more than 25 years. She has led the precedent-setting litigation and policy efforts advancing LGBTQ rights, including challenges with military service or challenges to military service, healthcare, education, and equal protection. So I'm hopeful that she's able to join us. We are also welcoming Christopher Green, a professor at The Ohio State University's Solomon P. Chase Center for Civics, Culture, and Society. Professor Green is a leading constitutional law scholar whose research focuses on the 14th Amendment and constitutional theory, and his work has been cited in opinions by the United States Supreme Court justices. And finally, we have with us Sarah Warbelow, Senior Vice President for Law, Policy, and Research at Out and Equal, a nationally recognized expert on LGBTQ civil rights law and workplace equality. She previously served as Vice President of Legal at the Human Rights Campaign, and now teaches civil rights law and public policy at George Washington University and George Mason University. Thank you all so much for joining us. Really, really appreciate you spending your morning with us. We will start, if it's okay, with Brian Sutherland. If you could give us your impression of the case, what are the highlights that you take away from your view?
Yes, thank you so much, and thanks for including me in this important discussion. I think I can, as the lawyer who worked on the Bostock case, I can be expected to be talking about that. And certainly, I was looking very closely at the way that the Bostock decision was treated in this opinion or these opinions. And to be honest with you, I was a little disappointed in the majority's analysis of the Bostock case. I didn't think that it was really engaged or adequately reconciled the Bostock decision with what was being decided in this case. I thought it was kind of thin in terms of the analysis there. Justice Gorsuch, who wrote the opinion in Bostock, explained a little bit better the distinction for the present purposes between what was held in Bostock and what was held in this case. But I think even there it was explained a little bit better by Justice Sotomayor in her concurrence. The idea there is that in Bostock, we were looking at Title VII, and the question was whether or not taking an adverse employment action against somebody is discrimination on the basis of sex within the meaning of that statute. And this question in B.P.J. being a different question of whether or not, not only whether or not the action is being taken because of sex, but also whether or not it is in fact the type of unlawful discrimination prohibited by the statute. And the answer on the that second question was no for the concurring justices who, in my opinion, explained that better. I'm not sure how satisfactory that is for me either. Simply because looking at Justice Gorsuch's concurrence, the discussion there is it doesn't. There's still a choice there in the framing about the injury that we're talking about under the statute. There's not a lot of discussion there, in my opinion, about the injury for the student who is denied the opportunity to participate in athletics. And frankly, that's kind of my criticism of the majority of opinion in general, is that while I was surprised to see such a really sort of full-throated defense of women's rights in this opinion, in ways that seem to be so focused on that so as to exclude the experience of other people, the plaintiffs in this case. And I was disappointed by that. But I feel that the discussion of the injury was lacking, and there was some blinders onto that, in my opinion, not only sort of in the way that the facts were described, but also in the analysis of Title IX. I also think too that helpfully there was a lot of qualification about the Title IX issue. In other words, that there was discussion in all the opinions about how this opinion does not control other questions of discrimination under Title IX. And that was something that was sort of front and center at Bostock, because everybody felt, and Justice Alito in his opinion in that case obviously was very fearful of Bostock being applied to other statutes which prohibit discrimination on the basis of sex. Well, everybody seems clear on the fact that this is sort of a case-by-case issue, which is, I guess, a good thing and a bad thing. It's very interesting to see the development of the Bostock decision in the analysis of Title IX. I do think the sort of other part of the story, which I can talk about, but really want to hear from some others, including Professor Dorff, about is the equal protection analysis. I mean, this is very deep. I was struck by the depth of the analysis by Justice Sotomayor, and I think that some very interesting and great material for teaching constitutional scrutiny in terms of when and how deference is given to legislatures, about which things, what does the fit between the classifications at issue and the goals of the government, what does that fit have to be under certain circumstances and all of that? And there's just a lot of meat on the bone there. So, no, I think the positive development for the Title IX claim is that there's a clear idea here that Bostock will apply to inform the sex discrimination discussion under Title IX in other contexts, if not this one. And then there's much to talk about with respect to equal protection. And I think with that, I'll probably pass it to Professor Dorff.
Yeah, no, I appreciate that. It's certainly worth highlighting that historically Title VII and Title IX in this context have paralleled each other. Maybe not identically, but they've definitely kind of tracked together with their interpretation of what it means to discriminate on the basis of sex. So it is a departure from that. Moving to Professor Dorff, I wonder if maybe you can speak specifically to what Brian was mentioning about the equal protection issue, the discussion there, and specifically the court highlights seems to apply intermediate scrutiny, talks about applying intermediate scrutiny, but really uses a lot of language associated with rational basis. Can you maybe speak to that a little bit also in your discussion?
Sure, I'd be happy to do that. I want to say one word about the statutory issue first, which is I agree with all of Brian's analysis. Please, by the way, call me Mike. There's a further problem with the case, which was that apparently the plaintiffs accepted for the purposes of this argument that sex as used in Title IX means what the majority called biological sex, which is I think what we would call sex assigned at birth. And as Justice Jackson pointed out in her dissenting opinion, she wasn't dissenting on the statutory issue, but she made this point clear. It's not obvious that that's the right reading of the statute, so that were it not for the concession, it's possible that sex could mean something more malleable, in which case you might get a different result. Unfortunately, as I read Kavanaugh's opinion, he doesn't just say, well, the parties have conceded for these purposes that sex means what I'll call it sex assigned at birth. He says that's what the statute means. And in that respect, I think it's quite inconsistent with the overall tone of Bostock, right? The whole theory of Bostock was that even though the Congress that enacted Title VII, 1964, didn't have in mind sexual orientation or transgender status discrimination, the word encompasses it logically. And there's nothing of that in this opinion. It's just, well, this is what they had in mind when they passed Title IX. So that's a bit of a problem. With respect to the equal protection issue, so first I should say I was one of a number of scholars who filed an amicus brief. We were very concerned that the court might reject heightened scrutiny for transgender status discrimination, and partly on the basis of the concurrences by, especially by Justice Barrett in last year's Scrimeti case. And one of the things we went out of our way to try to combat was her claim there that in order for a classification to be suspect or semi-suspect, it must be ascertainable at birth, which is plainly not true. I mean, religion isn't ascertainable at birth and it's malleable. And it's especially perverse with respect to transgender status, where the whole point is that there was a mistake in the, or there's a change from the birth assignment. But in any event, I was, one thing about the case is I was relieved to see that the court didn't go there. It didn't say anything at all about ascertainability at birth, and it didn't decide the question whether intermediate scrutiny even applies. But to your question, Kelly, right, there is a problem here, and I think the problem is twofold. One is that in the application of intermediate scrutiny, it does stuff that looks more rational basis-y, and that is one of the points that Justice Sotomayor makes, especially when they say, well, there's uncertainty, so we're going to defer and leave it to the legislatures. Well, that's not normally the way things work. This is, in fact, why the three liberal justices dissented. It's because they said it's possible that these classifications, as applied to trans athletes, are justified by the interests that the states allege in safety and fair competition. But you don't know that without a developed factual record. And that is normally the way things work under heightened scrutiny. So in that respect, I completely agree that it's not really intermediate scrutiny that the majority is applying. But there's a further problem with it, which is the core of the argument made in both B.P.J. and in Hecox, the companion case, although the core of the argument there is the case was moot. But the core of the substantive argument is a concession that sex-segregated athletics is generally permissible with respect to cisgender athletes, but given the burdens it places on especially trans female athletes, it's discriminatory and needs to satisfy heightened scrutiny. Well, what Kavanaugh does in the majority opinion is he devotes most of the opinion on the sort of substance. I mean, a lot of it is how wonderful girls' and women's participation in sports is, which, it's hard to disagree with that. But when he gets to the analysis, most of the analysis aims to show that the general policy, as applied sort of at the wholesale level, satisfies intermediate scrutiny. And then he says, in just a paragraph and a footnote, and there's no such thing as an as-applied equal protection challenge. Now, as Justice Sotomayor points out in dissent, that's not true. Caban is the leading case. There are other examples in which the court has entertained as-applied equal protection challenges. But his move is to say there's no such thing as an as-applied equal protection challenge, so we don't have to worry about that. Then he says later, well, we don't think this discriminates on the basis of trans status. We don't know whether heightened scrutiny applies, but even if it does, it fails it for the reasons we've given. Well, the reasons they've given are the reasons why the general policy, as applied mostly to cisgender athletes, is permissible. They haven't given any reasons why it's permissible with respect to trans athletes. He then goes on to do that, but that's where he just ignores the need for a developed factual record. And so I think there's a kind of bait and switch going on with respect to the arguments that they're making versus the ones that they're just sort of, shoving aside. If I can, I'll say one more thing about the case that really struck me, which was the sort of atmospherics of it. So Justice Thomas writes a short concurrence, which is basically just, culture war transphobia, basically denies the existence of trans people at all. I was grateful that nobody joined him on that, so that's something. Justice Kavanaugh's opinion is kind of a mixed bag culturally. That is to say, there is all this, nice rhetoric about girls and women's participation in sports, which is fine. The end of the opinion says, don't hate on trans athletes. We have some sympathy, which is also, appreciated. But in between, he repeatedly, as I said, uses this term biological sex, and not just because he's quoting it, but that just seems to be like, that's just what people are. That's a kind of trans erasure, I think. More broadly, it seems to me, if you step back from both B.P.J. and Scrimeti, the cases are rather obtuse because in both cases, they say, the core move is to say that in Scrimeti, the denial of gender-affirming care, and here the exclusion from participation in girls and women's sports. This is not discrimination on the basis of transgender status. At the same time that they are defining sex as an immutable characteristic assigned at birth, which they call biological sex. Well, the idea that that itself isn't at least prima facie discrimination on the basis of transgender status, to me shows a kind of fundamental misunderstanding of what transgender status even is. And in that sense, even if it's not rhetorically the kind of erasure you see in the Thomas opinion, it is substantively.
No, I appreciate, thank you so much. The language here very much matters. So I appreciate your highlighting that. Professor Menke, I'm curious, what are your thoughts from your perspective? You bring a really different lens, a more holistic view, I think, of, stepping away from some of the statutory construction, but I'm sure that, your research really informs some of this. So what is your take on the opinion?
Yeah, so I'm really excited to be here with you all today, and thank you, Professor Dorff, for that wonderful breakdown, because it was echoing a lot of my thoughts, and same for Brian's notes specifically about exclusion, right? Because I do think that this case really is about belonging, right? And whose perspective matters, right? It just requires us to think through what type of democracy we are and what type of country or democracy we want to be, right? So as a scholar who engages in like the deep work of legal history and tribal nations and indigenous peoples as polities in what is now known as the United States, right? This case raises questions about whether, we are regressing rather than progressing towards like a multiracial, multigender, multipolitical democracy, right? And so, the majority's opinion, I think the way that they are reading, right, Title IX's purpose and text as, on the basis of sex, it's encompassing only biological sex. And as, Professor Dorff said, or Mike said, just reiterating that throughout the opinion, right? And then saying that states are now free to discriminate against anyone who doesn't meet the state's definition of biological sex at birth from those programs at educational institutions that are federally funded. And I feel like that is, part and parcel of, this erasure that we're seeing throughout the opinion. And so, these atmospherics, as Mike called it, and thinking through, right, the history of gender classifications and intermediate scrutiny in general, right? Thinking through, right, if the government right, has to be serving some sort of important objective, right, and then not interrogating that, right, saying that West Virginia and Idaho are purporting to say that these opinions, or these laws rather, are supported because, they're concerned about the issues of safety in contact sports, right? And they're so concerned about um, women, biological women, being harmed in this sense. And I think that, accepting those as sufficiently important, right, to support a ban that really truly does burden transgender athletes um, is really problematic. And so, I was glad to see that the dissent, in the sense that they're characterizing the district court's decision of the laws, right? Like the way the laws are framed in the lower court is so critical, right? Because without them bringing that in, right, perhaps our future students wouldn't know, right, that yes, right, the law's sole purpose, right, this was happening in a time, right, it is happening in a time where, the court said the sole purpose and its sole effect is to prevent transgender girls from playing on girls' teams, right? That's critically important here, right? What is the motivating factor? Is this serving the government's purpose and objective? Um, and so, bringing in the lower court's characterization, and noting that there was no record of any transgender person participating in school sports in the state, let alone any quote problem with transgender students playing school sports or creating unfair competition or unsafe conditions, I think is a gift that we should not right let fall to the wayside in our discussion today. And I also really appreciated Justice Jackson's use of like bringing in, hey, right, the court should have left open the possibility that Title IX's definition of sex is more capacious, right? There's a reason to doubt that that concession with Title IX's reference to sex means only sex assigned at birth, right? We've historically construed Title IX broadly, right? We make sure that the statute protects against the denial of opportunities on the basis of gender, right? This is the purpose of these anti-discrimination statutes, right? To prohibit this disparate treatment of folks. And so I wanted to bring in just for a moment before I pass it on to my fellow panelists, the perspective from an Indigenous lens of and I hope that this is, we'll have a court one day that can return to, right, this more capacious view that Jackson alludes to of gender and sex, right? Because at our best, right, this country fosters a sense of belonging for all of its citizens. And at its worst, it excludes its citizens, right? Whether that exclusion is refusing citizens legal protection in the courts or refusing them access to discriminatory free education, right? I bring this Indigenous focus because Indigenous cultures and communities have historically had more than two genders. And in many of these cultures, these individuals, I'll use the term two-spirit for simplicity's sake. There's a lot of different terms, some of which are in Indigenous languages. But those individuals are highly valued and often served important leadership roles in the community, right? And I think it's important to note that if we want to live in a multiracial, right, multi-political democracy, I use that specifically to be bringing forth, right, consideration of the first sovereigns or tribal nations into our conversations more regularly, especially vis-a-vis constitutional law. But certainly, this global context of like colonial gender binaries, right? That this opinion reifies. And certainly Justice Thomas's concurrence is very, very reminiscent to me of the problem with not recognizing our movement in this country to progress toward a multiracial, democratic, multi-political, multi-gendered society, right? And to recognize that the erasure that has happened historically with Indigenous peoples, cultures, ways of knowing, ways of being, and reduction and forced assimilation of indigenous peoples to try to fit into these gender binaries, right? That's shifting. There's a shift in our country towards understanding and re-indigenizing that history and regaining access to those ways of knowing. And so I think this opinion really does call for us to think critically about that. And I know one of the amici had mentioned something along these lines. And so it's wonderful to see that that is happening now. In the court. And so I'll move to our next panelist, but I just want to wrap up by saying that, I do have hope for this country despite opinions like this, thanks to our dissenting liberal justices, Justice Jackson, Sotomayor, and Kagan.
Thank you so much. I think you bring a really great question. I'm reminded kind of thinking back to law school when you have those cases where facts really matter. And I think that the dissent highlights well that the facts here are important, that the majority doesn't employ them perhaps as much as it should. And the impact, when we talk about a ban on trans athletes, the impact is a handful of students, right? We're not talking about a broad swath of society or culture. And so I'm curious as we kind of transition into Professor Green and your thoughts from a societal kind of cultural perspective, what are your thoughts on the case?
Okay. Yeah. So I don't have a whole lot of focus on culture, despite the the name being in our center. So yeah, I'm not any kind of specialist on these particular kinds of factual issues, but I have spent a lot of time on the 14th Amendment, and I was kind of flabbergasted just yesterday looking. So this comes out at 10 Central, about 10:30 Central. We get the citizenship case, and it is unbelievable how much time they spend on the history of Reconstruction at 10:30 o'clock, at 10:30 a.m. I guess y'all out in the West Coast, maybe that woke you up. A little bit of Reconstruction history at 7:30, but there isn't a word about it in the B.P.J. opinion, and it's not because there is information out there. So just broadly, I've got some pretty radical views. I want to burn down the whole non-discrimination view of equal protection. I want to move anti-discrimination law to citizenship. And Justice Jackson, in her concurrence in the birthright citizenship case, she's quoting all this material that totally shows that. So in 1864, all these people are like, hey, we have got to be American citizens with the same rights as all the other American citizens. Nobody was saying, hey, what we really need is equal protection of the laws. Protection of laws means protection from violence. It means the opposite of DeShaney, roughly. So I was disappointed they didn't even engage in it. So I wrote an amicus brief in Skirmetti saying, hey, y'all should burn this, basically melt the tiers of scrutiny down into, there should be, I think, one question: is the government treating all citizens with the solicitude and concern for their welfare that all citizens deserve? So it shouldn't be a focus on classifications. Basically, so this whole question, are there as applied equal protection cases? I would make all of the challenges as applied. The question is, you have this particular citizen or whoever the plaintiffs are suing and saying, hey, other citizens who are in similar situations are getting more solicitude for their welfare than I am. And so the whole question, the tiers of scrutiny, A, they're made up. B, they're using the wrong clause. C, it's just not a good system. And the main problem as a policy matter with the tiers is this gulf between rational basis and intermediate scrutiny. So you get cases like this. And I think the justices, Justice Kavanaugh, he has in earlier cases said, well, I don't know what intermediate scrutiny is. He said in Rahimi, these are completely made up. And now he's like, oh, guess I got to apply this thing. It seems to me, wants to apply something in between rational basis and intermediate scrutiny, but the formalism of the earlier cases, which he's unwilling to re-examine for complicated reasons, I suppose. Maybe they're simple. I don't know. I don't know what they are, though. But the failure to have anything between rational basis and intermediate scrutiny causes a lot of these weird things. So you get these kind of rational basis with bite cases. You're like, why are you giving all this scrutiny, even though it's rational basis? And then you've got in Skermeti, you had the deployment of Geduldig, this idea that pregnancy discrimination isn't sex discrimination, which is really weird. You got this thing, which says like, oh, it's really, really important to have women's sports of a certain kind. When I'm like, I don't know, how important really is that? But it gets this important label just because they're going with intermediate scrutiny. One question I have been trying to get people to pay attention to, and it was I did, if I wanted to just write an amicus brief on this issue, I suppose I should have written it. But the symmetric distinction question, does a symmetric gender distinction get intermediate scrutiny? Well, after yesterday, yes, absolutely. Is there any rationale? No. So you might remember in the 70s, we had Craig versus Bourne comes up with this intermediate scrutiny. And they immediately grant cert in a new case, Vorsheimer, from the Third Circuit, about separate schools, like gifted schools for girls and boys. And they split 4-4 on whether that gets, they don't have opinions. So they split 4-4 about the case. Justice Rehnquist recused. Okay. So they say we're not going to decide whether symmetric gender distinctions get heightened scrutiny. And then in MUW in 1982, they have a footnote 1 saying we're not going to decide it. C. v. Vorsheimer. U.S. versus Virginia, note 7. They say we're not going to decide that thing. C. MUW. And then what do I get in page 15 of B.P.J.? I can say, well, you gotta be substantially related to something important. C. Virginia. And MUW. Well, what about note 7 in Virginia? What about note 1 in MUW? Well, we're not going to talk about that. We're just going to have the sentence. The West Virginia and Idaho laws authorize separate female and male sports teams, and the laws limit women's and girls' sports teams to biological female. And so doing so, the laws make a sex-based classification that triggers intermediate scrutiny. So like, okay, I guess that's all the. I feel like Darcy. Like, is this all the explanation I'm to expect? The ground, looking at the way they do intermediate scrutiny, I think it kind of adds another argument like, hey, what is this? What is this game we're playing? So it gives another argument for melting it down, but the complete lack of interest in melting it down or kind of rethinking things in terms of citizenship was a disappointment for me. But I'm always looking on all silver linings have a touch of gray, as they say. Yeah, I don't have a whole lot more to say specifically. I could ramble for hours about the actual historical basis for all of that, but the court's not interested in it. But I would just just go to Jackson's concurrence in Trump in the Trump v. Barbara case and look that stuff up. You'll come up with a pretty good a picture of citizenship as the basis for anti-discrimination law. So.
Yeah, I appreciate the perspective. It's interesting. I mean, a variety of cases have done this to us over the years, right? Where we see little snippets being chosen and handpicked to serve the purpose of supporting the opinion without a lot of consistency. So I appreciate that. Let's see, Sarah, if you could, we're going to transition and I would love to hear your perspective as someone who's really kind of boots on the ground doing this work. What are your thoughts?
Yeah, I'd be happy to talk about that. Although I am a little less boots on the ground this day, I'd really like to talk a little bit about the Javits Amendment. So let me start by saying, look, even before the Supreme Court's decision, there were already very clear harms, not only to transgender women and girls, but to all women and girls from the adoption of these laws. There were investigations into whether or not non-transgender girls were lying about who they were, pulled off of teams, prohibited from playing in athletic competitions. And so we really can anticipate that these negative outcomes will continue, and that more and more young people will continue to be subject to these types of investigations and claims, particularly in states that have statutes that effectively allow any individual at any point to challenge whether or not an individual girl is entitled to be a member of the team. In order to inform sort of the next set of conversations, I do want to look a little more closely at the Javits Amendment and the court's analysis on the statute. And that's because the Javits Amendment makes the issue of sports arguably unique with respect to how Bostock might be applied to either Title IX in the future, but also how the court may look at new questions that arise in the Title VII context as well. So let me start by saying there is no reason that the court had to come to the conclusion that it did with respect to the statute. But since it did, let's just sort of recognize what that means. The Javits Amendment, which was adopted in 1974, actually statutorily allows for differential treatment on the basis of sex within athletics. And that's fairly unique. When we look at the rest of Title IX, there are some other gender-based exceptions, including things like father-daughter dances. But when we look at the core of what constitutes discrimination, generally speaking, in admissions, harassment, which of course is a court applied rather than statutory, looking at issues around discipline, right? That these are all gender neutral. And so there is no permissibility within the statute to treat students differently on the basis of sex. So when there is an opportunity to challenge whether it's a statute or individual treatment of a transgender youth, or for that matter, an LGB youth on these grounds, there's ample opportunity to distinguish B.P.J. From future application of Bostock to Title IX itself. Professor Rodriguez, as you noted, the court historically has considered Title VII and Title IX in conjunction with one another. The federal courts broadly have applied sexual harassment, interpretations of law, sex stereotyping from the context of employment directly into education. And there's no reason to hold the Bostock decision differently, but for arguably this Javits Amendment. It's also important in the employment context because Title VII also does not contain broad permissibility to treat people differently on the basis of sex. Even the bona fide occupational qualification provision is very narrowly been permitted by the courts in very limited circumstances. And so it would be bizarre moving forward to allow this decision to have a negative impact on the Bostock decision, directly impacting employment, and really should have very limited effect in applying it to other areas of educational discrimination. I mean, Kavanaugh himself, writing for the majority, notes that the typical employment or educational opportunity questions is very different in his view than sports applies. I also want to address some of the misinformation that we're seeing circulating out there. In no way does this decision prohibit states and school districts from adopting policies that support transgender young people in participating in athletics. It is upholding those statutes that ban participation, but it is not addressing whether or not Title VII, in fact, would in some way require discrimination against transgender people in athletics. That is not what's happening here at all. The other misinformation that I have seen floating around is that somehow this decision authorizes the invasive investigation into a young person's sex for purposes of Title IX. And we know that it's happening, but that's different from the court authorizing it. The court does no such thing. The court, in upholding these statutes, simply is saying that the school districts and the states can mandate that a young person play only consistent with their sex assigned at birth, but it does not address the question of how that is determined. In most circumstances, we would anticipate that that would be based on a birth certificate, kindergarten enrollment records, non-invasive techniques. And in fact, if a young person is subject to an invasive investigation of sex, there's nothing stopping them from suing under Title IX or other statutes prohibiting abusive behaviors. And so I just really wanted to make sure that we clear up some of those misnomers as we're looking at this issue.
No, that's what point well taken. And I want to dig into that so much more, but I'm going to leave that for the second panel. Let's see. We've got some questions, so I wanted to make sure that we had some time to ask those. Let me see if I can find where they are. Before we start there, I'm going to dig for the questions that are coming in from audience members. Let's see. I'm curious if anyone has thoughts on the majority looks to the NCAA, the U.S. Olympic and Paralympic Committee, and the IOC's, the International Olympic Committee policy changes, and uses them as, corroborating evidence, support that individuals assigned male at birth retain an athletic advantage even after hormone therapy. I'm curious, do you have thoughts on that? Do you have thoughts on the way the court is relying on that, especially in light of the dissent's note that those changes followed some pretty direct pressure from the administration? I'm curious if the panel has any thoughts on that.
I mean, I'll say a word. Yeah, that when I saw that line in the opinion, especially with respect to the NCAA, where there's the clearest line of pressure, right? I thought, well, that's sort of double counting, given that that's coming from a Trump administration that thinks, contrary to what Sarah just said, not only are these rules permissible, but they're actually required by Title IX and equal protection. Now, it's true, the opinion says we're not addressing that. That's the subject of pending litigation. I think that argument is outlandish, but it's being litigated. So yeah, to rely on that as though it's sort of independent did seem to be gilding the lily, a little bit unlike what they did in Scrimeti, right? In Scrimeti, I thought they did make some effective use of the fact that other countries had pulled back a bit from some of the use of hormone therapy and puberty blockers. Here, it does seem like they're just counting the politics twice, as it were.
I appreciate that.
I think it's also important to note, that the goals for educational athletic opportunities are very different from professional or quasi-professional athletic opportunities. And in fact, Kavanaugh lays out very beautifully what some of those goals are. And so to treat policies governing adults the same as policies governing students when there are different objectives, including educational growth, exercise, teamwork, really misses the mark.
I thought it was interesting. A few years ago, there was an antitrust case, and Justice Kavanaugh is going on and on and on about how terrible the NCAA is it's a walking, talking antitrust violation. So the idea that it's not just a national organization of kind of taking a poll of everybody and a grassroots kind of indication of what people think about athletics. It's this national organization with a whole bunch of political stuff, and if you can manipulate the stuff at the top, it's just like the American Bar Association or the American Psychological Association. They're filing these amicus briefs and a Obergefell, and it's the smartest people on that side, so it tells you something that they're taking that position, but taking it with a grain of salt anytime there's kind of a big structure, big bureaucratic structure making decisions, rather than, if you don't have time to engage the peer review, and they clearly don't have time, it's probably better than nothing, but I would say, only a little bit better than nothing.
Yeah, I appreciate that. Thank you all so much. We have a question in the that's come in from the audience, and I'm going to try my best to summarize this. Curious if the panelists might address how much of the decision should be understood because it specifically involves sports. So that the idea being that even if one accepts that there are cases where women and men, and the question is specifically not using terms gender assigned at birth, et cetera, but I assume that can be implied. That even if there's a fairness rationale for separating them, there are many areas in which case, including in sport, that they might not be. So for example, archery could be a sport where any genetic advantage that one might have is likely not to be different between women or men, and specifically between women and cisgendered women. So all women versus cisgendered women. I wonder if this panel could speak a little bit, given those examples, to whether we can imply anything or infer anything more broadly beyond sport. Is this a specific sports issue case? Has the court narrowed it to that extent?
I think it is a lot about sports. I found that I guess I'm just not as into sports. So I'm like, well, how important is this? And the one point where they say, oh, this is completely unlike Bostock, because Bostock is professional hiring stuff, and this is sports. I'm like, don't those overlap? I mean, what about like professional sports or like hiring people related to sports? So the notion that's but I think the opinion is clearly based on sports being different and somehow its own thing. But that didn't strike me as super plausible.
I agree with that assessment that it treats sports as unique and different. But I think part of the question here is whether or not there are different rationales, arguably, for different types of sports. And the Javits Amendment actually contemplates that. What it instructs the precursor to the Department of Education to do is to make regulations that take into account whether or not it's a contact sport, the competitive nature of the sport, and in upholding blanket bans on transgender students participating in sports, it strips out any nuance for how certain types of sports might arguably be treated. I mean, I want to be clear, that my view is that transgender young people should be able to play sports, all sports consistent with their gender identity. But, sort of in terms of what the requirements are under the Javits Amendment versus what the court has upheld here, there is a real difference.
And I'm going to ask one final question, and then kind of start transitioning over to the second panel of folks where we look ahead to future implications. Professor Menke mentioned two-spirit folks. I've written on Title IX as applied to non-binary folks. I'm curious, do you all have thoughts about the erasure or lack of acknowledgement in the opinion around intersex persons and who don't fit the gender binary, even biologically, right? We talk a lot about not fitting the gender binary in gender identity, but when the biology is not comporting with a particularly agreed upon assigned gender assigned at birth.
I have one small thought, which is that given what this court says, I think they are likely to just be very permissive with respect to what many of us might regard as peculiar policies. So, like, think about androgen insensitive XY person who appears phenotypically female, but do they define biological sex as having you're male if you have a Y chromosome, full stop? I suspect that states will not specifically address that in their statutes, and it'll be decided on a kind of ad hoc basis in random kind of ways, sometimes maybe sensibly within a certain framework, sometimes not so much. But this whole idea that, this is complicated, this is science, we're going to defer to the states, I think means that it's not going to be decided by this court. That's just my prediction.
Just also to note, I don't remember the two specific statutes at issue, and perhaps somebody else does, but many of the state statutes have an exception for intersex students. And so they do treat intersex people differently from transgender and non-binary folks.
Any other final thoughts? Well, I want to thank you all so much for your time and for sharing your thoughts with us today. Really, really appreciate it. And I'm going to turn it back over to Professor Siegel.
Well, thank you so much, Dean Rodriguez, and thank you to all the panelists. It's a great first panel. Really got a lot of different perspectives out, a lot of issues covered. We are going to transition now. The first panel is welcome to stay with us and listen in, and if they feel like it, pipe in. But we're going to transition now to the second panel. I have almost all of the panelists here. We are a little ahead of schedule, but there's nothing wrong with that. This panel is equally distinguished to the last panel. I'm thrilled to have everybody here. As Kelly said, what we're going to be doing here is focusing a little bit more on future cases, future implications, doctrinal implications, theoretical implications. But people should feel free to speak about what speaks to them. Plenty of time to talk about whatever you think is interesting about the cases, about their context, and everything else. So I'm going to briefly introduce the panel, and then we're going to launch into the remarks just like Kelly did. So I am joined, first of all, by Jessica Clark, the Packard Professor of Law at the USC Gould School of Law, a prolific author of award-winning scholarship on anti-discrimination with a focus on sex, gender, and sexuality. I know she's involved in an amicus brief in this case, like Professor Dorff and maybe perhaps some of the others, and she will kick us off. After that, we're going to hear from Shannon Minter, the Vice President of Legal, the Legal Director at the National Center for LGBTQ Rights, a prolific litigator, national expert on these and all sorts of other issues. And I'm really looking forward to hearing from Shannon as well. Then we'll hear from Noah Ben Asher, Professor of Law and Associate Dean for Faculty Scholarship at St. John's University School of Law. Yet another scholar who focuses on a variety of issues related to gender, sexuality, and legal theory. Also an award winner. Lots of fascinating work to draw upon. I'm sure we'll have interesting things to say about today's case. Our next speaker is going to be Evan Wolfson, the founder and leader of Freedom to Marry, the organization that managed the campaign to win the right to marry for LGBTQ plus individuals in the United States, for the right to same-sex marriage. Well-known speaker, well-known expert, not just on legal issues, but on campaign strategy, social justice reform in general, and another person whose perspective we're thrilled to have. We're going to be joined by Chan Tove McNamara, an emerging scholar, finishing up a VAP at Cornell before joining a faculty as a full-time professor, I believe actually as of today. Another award-winning scholar. Everybody's won the same awards and published in wonderful journals, and researches examines the nature of discrimination, the purpose of legal regulation, the dynamics of identity, status-based inequality. Love to hear what Chan has to say. Finally, we may be joined by Darren Hutchinson. Darren is a frequent participant. I think he'd be the only person who would have spoken at all four of our rapid response webinars. He's the John Lewis Chair for Civil Rights and Social Justice at Emory Law School, a distinguished record of scholarship, service, advocacy in issues related to equal protection, equality in general, and we may or may not be joined by Darren to conclude our program. So a wonderful slate of speakers, just like the first panel. I'm very curious to hear what everyone has to say. I'm going to leave the questions open-ended. I'm sure I'll follow up with some questions specifically, but just kick the ball over to Jessica to get us started.
Thank you. It's such an honor to be invited to do this and to be on a panel with so many people that I admire. I'd like to say some things about this B.P.J. opinion that I'll put into three categories in terms of implications going forward: the good, the bad, and the ugly. So to put B.P.J. into some context, before the Supreme Court started taking cases on transgender rights, there was a lot of progress in the lower federal courts, a lot of huge victories in constitutional litigation by transgender folks. This case threatened a lot of that. There could have potentially been some very damaging rules that could have come out of this case that I know that I was worried about, a lot of people were worried about, that didn't come out of this case. So I'm going to start with some good things about it. First of all, it didn't say that Bostock applies only to firing discrimination in the context of Title VII. It didn't say that. That could have been really damaging if it had said that. It doesn't say that under Title IX that harassment of LGBTQ students is permitted. It says that Bostock doesn't apply to this narrow sports context. But it doesn't say Bostock doesn't apply to co-ed sports. It doesn't say Bostock doesn't apply outside of the athletic context. So that's good. The second thing it didn't do is it didn't say rational basis review applies in the equal protection context. It could have pulled something like Scrimity and said, even though this law on its face classifies students on the basis of sex, we're going to pretend it's another kind of classification, one based on age and medical treatment. The court admitted this law classifies on the basis of sex, and it applied intermediate scrutiny, a tougher standard than rational basis review. And a third thing that the case didn't do that the last panel already mentioned, it didn't say that transgender people are not a quasi-suspect class. That is something that Justice Barrett wrote a concurrence on in Scrimity. She thinks transgender people should simply receive rational basis review when laws target them. There are a lot of good lower court opinions that hold that transgender people are a quasi-suspect class, and so discrimination against them receives intermediate scrutiny. Those are still good law. Now, in terms of bad doctrine, unfortunately, this case says that under Title IX and the Javits Amendment and implementing regulations, the definition of sex is biological sex, although it doesn't define what biological sex means, except to say it's not gender identity, nor is that thought through, since it wasn't argued by the parties. And very arguably, with respect to Title IX generally, this is dicta. This isn't part of the holding at all. The holding, I think lower courts can say, is actually about these regulations. So I think we're going to see debate about whether or not that is dicta in later cases. A second thing that is bad here is the way that the court applied intermediate scrutiny is very watered down, as Justice Sotomayor described in her dissent. I'll say it was watered down, but it's not unprecedented because there are some cases in the line of intermediate scrutiny precedents that did more or less the same thing in contexts like the military, immigration, and sexual assault. So sometimes the court does deviate from its intermediate scrutiny precedents. Unfortunately, this is an example of that. It remains to be seen whether lower courts, though, can distinguish this case from new scenarios. And there's lots of reasons to do that from the opinion, which focuses very much on the sport-specific nature of this. And then a third bad thing about it is it fails to confront the reality that these sets of sports bans do classify on the basis of transgender status in a way that Professor Dorff explained on the earlier panel. And it seems very obtuse to say that's not what these laws were all about. Anyone familiar with the legislative debate over these laws knows that they were about transgender girls and women. So those are some doctrinal points that are bad about these cases. What is ugly about them? Justice Kavanaugh refers to the transgender plaintiffs in the cases throughout as biological males in a way that allows some real slippage in the analysis and is a troubling form of erasure. I also think we see here a very results-driven outcome. The court simply doesn't want to get involved in transgender rights controversies. It is abdicating its role in enforcing the Equal Protection Clause when it comes to transgender people. And it's proving again that litigation strategies that end in the Supreme Court are a hollow hope for social movements that want to achieve change. Our Supreme Court needs reform. This kind of one-sided opinion that doesn't engage with arguments on the other side is only possible because we have a 6-3 conservative majority that doesn't have to engage with the other side, that doesn't have to make a decision that's bound to facts or law, as Justice Sotomayor explains in her dissent. And so, as lawyers and advocates, I think when things get up to the Supreme Court, our role is now in trying to limit the damage and mitigate the harm. And so, that's an unfortunate lesson that we're learning once again from this opinion.
Thank you very much, Jessica. I believe that our next speaker is Shannon. I'm not going to guide the conversation. I'll do it at the end if we have time. What were your thoughts, Shannon, and what lessons do you want to take from this?
Oh my gosh, so many thoughts. I don't know. There's so many things that are true at once about this decision. Jessica, I agree with everything you just said. I love the Gerald Rosenberg reference to the Hollow Hope. Yeah, nicely done there. Yeah, I mean, I just want to say a word first as somebody who's been working on this issues around transgender people in sports for I am just way too long, since like the early 1990s. And I just because I think it's interesting for people to know, man, has the landscape changed on that? Like, when I first started working on this stuff, it was with a lot with little kids. Like, we represented Jazz Jennings, who some of you may know now is like a young adult in her 20s and had a reality show about being a transgender girl and all that. She was like 9 years old and wanted to play girls soccer in Florida, but way long time ago. And that, that situation, the U.S. Soccer, which is, I believe, the world's largest recreational sporting association, just ended up quietly changing its policy to prohibit discrimination against either transgender or gay kids, actually. And that was really typical. I mean, for the longest time, no one really was focusing on this issue, and that was wonderful. If only we could go back to those days. I mean, it was just like we were able under the radar to have very direct, kind of normal policy discussions about what makes sense, what to do with these kids, what to do with these athletes. We saw so much progress being made, like almost all of the big recreational sporting associations adopted non-discrimination policies, U.S. swimming, soccer, a bunch of them. All these little kids were able to play. There really have not been, to my knowledge, any significant incidents relating to any of that. Some of the country's biggest school districts back in the late 90s, like Los Angeles and in San Francisco and California and some of the Northeast, just kind of quietly adopted inclusive policies. Again, no problems. California in 2013 actually codified that, and there's a state law in California that, yeah, kids have to play based on their consistent with their gender identity. California's a big state. There's so many kids, and it's just like until very recently, no one has raised any concerns. We worked with the NCAA, and I give them so much credit. They're under so much scrutiny now on so many different fronts, but they were had a lot of foresight about this, and long before it became a topic of much conversation, they put a policy together back in 2010, and we worked real closely with them on that. It made so much sense. It was like, if you've been on medical treatment for a year, a transgender woman who's been on medical treatment for a year is eligible to play on a women's team. And I mean, everything was really going well until this issue became so highly politicized. And now, of course, it is I think, the single most toxic, polarizing issue relating to transgender people in the country today. And it has done a world of harm to the cause of transgender equality, not just in sports, but across the board. And we have lost many, many people on this issue. And I think people wrongly have the view, possibly even people participating, even panelists on this may have some panelists may have this view that this is kind of an all or nothing proposition, that either we're saying, everybody just has to play based on whatever you say your sex is or your gender identity, or nobody, or a complete exclusion of transgender people. And that's not how this is rolled out. It was, like I said, rolling out in a fairly rational, policy oriented way with like, for young kids with recreational stuff, yeah, there shouldn't be any restrictions. For when you get to elite competition like the NCAA, of course, we need some kind of reasonable medical requirements to ensure some degree of fairness. And probably the NCAA rule might have needed to be tightened up a bit more. to make sure that, they all they did was say you need a year of hormone therapy. For example, they could have moved to demonstrating that your testosterone levels have been reduced to those that would be within the typical range for a non-transgender woman, something like that. Anyway, there you can certainly craft different policies for different ages, sport, level of competition. I mean, we could just approach this as a reasonable policy issue, but that's not what's happened. Anyway, I just wanted to share that. I thought it'd be of interest to people. But in terms of the decision itself, I mean, Jessica, thank you. There's so many good things one can say about how narrow it is and all the things it did not do and did not decide, and I am grateful for all of those things. And I do think in terms of just our understanding, as I think most people on these panels are pretty progressive in terms of our understanding of how this decision is received by the larger world, including moderate conservatives. I think a lot of moderate conservative people see this as like a very reasonable decision that did not endorse banning transgender kids, that is not attacking these kids, and that took a sensible approach to like not taking a view on the science, letting states and schools decide which way to go. So I appreciate that. I mean, I appreciate that impact of the decision. And I'll say one potentially positive thing about it, but then aside from the one potentially positive thing doctrinally, I think the rest of it is kind of like, it is kind of like the gun in a Chekhov play. It's just lying there ready to be used in a lot of bad ways in the future, I fear. But the one positive thing doctrinally is I do think, unless I'm missing something, I'd be curious if anyone has a thought on this, that what they say about Title IX, which is essentially just that it does not address this issue, it's just silent on this issue, that I'm hoping they're going to stick to that in cases that are coming up through the pipeline to them, as they acknowledge in footnote 1, where some plaintiffs are alleging that Title IX requires exclusion of transgender girls. I hope they just continue to say, nope, it really doesn't speak to that issue one way or the other. I think the Gorsuch spending clause point would reinforce that. The same way there's no clear direction to include transgender girls, well, there's no clear direction not to. So I hope that works. I think the one place that could fall down is the Kavanaugh emphasis on the zero-sum nature of the equal opportunity situation. That if you allow a transgender girl to play, you're denying another girl an opportunity. I think there's ways to address that, but I'm just guessing that's where the fight on these upcoming cases is going to lie. But I'm kind of hopeful that what they say about Title IX, though I don't agree with it, I'm hoping that it at least will cut both ways, and that they will not come up with some new novel way to understand Title IX that in fact requires discrimination. The stuff that's worrisome, and it's sort of like the gun lying there, is their equal protection analysis is so terrible. Just every way you look at it, for everybody involved, it's so awful. Makes no sense. Clearly, hugely diminishing the level of protection for women and for the level of scrutiny applied to sex-based classifications, and that's just terrible. And I think in the long run that may be the single worst thing about the decision. It may be just end up being way worse for women generally. Uh, than even for transgender people, I don't know, or at least as bad for women as for transgender people. Remains to be seen, I suppose, what is done with this analysis in future cases. But the horrible thing is, they've now set up this paradigm for equal protection challenges brought by a transgender person to being excluded from a sex separated facility, service, whatever. It's hard to see how to win those now, because they're saying, well, as long as there's some underlying sufficient reason to have sex separation, the fact that harms transgender people as a class is not something that intermediate scrutiny can address. Again, I think there's ways we can push back on that in specific context, and I intend to do that with all my might. But just I hate that they've set that paradigm out, and now it's like a battle, a challenge that we're going to have to deal with. I do think in other contexts that don't involve sex separated facilities or services, we're still alive. Bostock analogy apply, or analysis would apply as well in equal protection context, employment, other types of school protections. maybe healthcare in certain settings. So that's hopefully going to be leave the door open on those. Anyway, kind of a very mixed bag. Could have been a lot worse, but it's I do think the equal protection aspect is pretty bad.
All right, can everyone hear me? So thank you for having me here. It's an honor to be on this panel with people whose work I admire, and I have followed and admired over the years. So some of my comments have already been said by others, and I won't repeat them. But in the brief time that I have, I want to make one conceptual observation, and then just a few other small points about the text itself. And my one conceptual observation ties this case to Scrimetti, and to the state of the Supreme Court in general on trans issues. And so I've been thinking about the Scrimetti decision and now about this case as what I call gender trouble, obviously drawing on Judith Butler's work. And now I see what B.P.J adds here is severe gender trouble, and I'll explain why. I think it even takes us further down in this troubled situation that the court is in. At the very plain level, the court, just amongst the different justices, have, as some of my colleagues have already mentioned, different definitions of sex that don't necessarily cohere with each other. In the case of Justice Kavanaugh, it also doesn't cohere with himself in the same decision, where, as Professor Clark noticed, he calls the plaintiff, he starts in the first part of the decision, the plaintiff is a biological male who takes puberty blockers and identifies as a woman. But then at the end, it's like those transgender people and the female athletes, and then I don't even know who he's talking about anymore. So he slips into his own rhetoric. The biggest picture is that I've been mapping in my articles just those different definitions of sex and gender identity, all of which lead to, at least some of them, to erasure, complete erasure of trans people. So let me just give you a brief kind of example within this case. At stake was a statute in West Virginia, and the statute itself had a definition of biological sex, which was, and I'm quoting, an individual's physical form as male or female based solely on the individual's reproductive biology and genetics at birth. So this was a complicated definition. None of the justices, except Sotomayor in her dissent, mentioned that definition of biological sex. And I don't think it's a coincidence. Kavanaugh, for the majority, talks about, as you have mentioned, biological sex. He never really defines it. He says since the 1970s, this was the definition, not gender identity. So it's what it is. And so biological sex, I cannot define, says Kavanaugh, because it's genetics and it's hormonal status and it's chromosomes. It's all this stuff that we know counts as biological sex, but he will not define it. He will not defer to the statute. Neither did Roberts and Scrimetti. The same move happened in Scrimetti, where the Scrimetti statute had a definition of sex that Roberts did not take. Instead, he talked about biological sex. My theory is that they don't want to do it. Those who call it biological sex don't want to do it because they simply can't. And they know that they're running into contradictions. And so, for example, Alito knows that there's a contradiction, and in his Scrimetti concurrence, he says, well, it's all genetics. It's just genetic sex. Justice Barrett calls it definitely ascertainable at birth, whatever that means. Who knows? But that's her definition of sex. And so we have different definitions of sex. And there's a correlating column in my charts, which is, okay, these are the definitions of whatever you're calling biological sex. Then what is gender identity? So for some, gender identity doesn't exist. For example, for Justice Clarence Thomas, it just doesn't exist, right? There's just man, woman, and there's no gender identity. There's no trans people. And the same with transgender existence. Then there's a correlation between those who use the term gender identity and trans people, but those who don't often avoid both terms. And Justice Gorsuch is many times in that camp also, just the avoider. And I call that approach gender identity erasure. And that's a bigger campaign that we've seen over the last 10 years to basically erase the concept itself of gender identity from different legal statutes, from court rules, and from the general language to say gender identity is ideology, it doesn't exist, and so we're going to erase it. And we see this project, as again, as some of our colleagues have said here, happening in B.P.J. So the project of erasure continues in this decision. Interestingly, and I noticed this as we were speaking and in this exchange with Professor Dorff earlier, even Justice Jackson, when she's saying there was a concession that under Title IX, biological sex means sex assigned at birth, when I go to the decision, that's not the case. The concession was that it means biological sex. So B.P.J. does not seriously contest that the term sex in title means biological sex. That's what Kavanaugh says. He doesn't say, as Justin Jackson says, meaning sex assigned at birth, right? That she adds. And then adding again to the confusion of what is actually meant by sex assigned at birth. And then she could have cited Professor Clark's article about what sex assigned at birth is, right? But she doesn't do that. So I think the confusion is across the board. Why is this happening? I don't think it's because they're stupid. I think we're in I mean, I think they are stupid, but I don't think that's the reason. I think we're in a point in our culture where there is this kind of redefinition, crisis, emergency, think of it as you will, around the concept of sex, around what sexual difference actually means. And we have different discourses going on about it. And we have a politics of the court now taking on these issues and making really political declarations, such as the executive orders, about what sex actually means, because it is in crisis, because we don't know, we try to identify what it means. And here's the good news in the good, bad, and ugly, is that it's not working for them because they can't identify what it means. So they're creating bad precedent for trans people, but at the same time, they're revealing their own lack of awareness. Why is this different from Skrmetti? Skrmetti, as some of my colleagues have noted, does not turn on that gender trouble. They could have done without the gender trouble and the holding would still be the same. In B.P.J., it's the actual question because no one contested that there could be sexual differentiation here. But the question is, who counts as a girl, right? And so the three dissenters say, no, she counts as a girl. B.P.J. counts as a girl. The other six say she doesn't count as a girl, but they can't explain why. So here, the gender trouble is at the core of the decision. It's this positive. The court cannot define sex under Title IX or under the Equal Protection Clause, and therefore reaches the conclusion that is just vibes, right? She's not a girl because we don't want her to be a girl, but they can't really decide it. Obviously, Kavanaugh's, these are now my small points of annoyances, and I'll stop. Kavanaugh's concern for women and girls, I just couldn't stomach that when he's talking about, because obviously if they're so concerned, they wouldn't have taken away reproductive freedom for women and girls. That's been mentioned. His avoidance of the term transgender throughout the decision is really disturbing. Like, why is he not just saying transgender? He needs to go into like a whole paragraph describing who he's talking about. And then he has a footnote about male-identified plaintiffs who would try to compete in women's sports, even though, who does that? Does he have one example of someone who would try to compete in women's sports because they're shorter, right? These are just hypothetical annoyances. And then he doesn't understand Skrmetti. He miscites Skrmetti itself to say that Skrmetti itself says, and I'm quoting him, the laws do not classify based on gender identity or transgender status. The laws classify on the basis of biological sex. That's not sex. That's not what Skrmetti said. Skrmetti said it does not classify on. So he actually also misreads Skrmetti itself. Finally, I cannot but end with Thomas's authority for how he defines sex. I don't know if you've noticed, but he cites a philosophical studies journal from 2000 that says that women are women because they're born women or something like that. And that's his authority. It's a philosophical claim that trans people are lying and therefore are discriminating against him by lying and pretending to be whatever they are. And I'll stop here.
Thank you so much for Noah for all of those insights. I believe the next speaker is Evan, and love to hear what you have to say.
Well, thank you. Before I start what I was thinking of saying, I just want to underscore, so I don't forget, something Jessica Clark said, which is we need to reform the Supreme Court as part of the many structural reforms that we need to enact in this country after we reclaim political power. And our most urgent task, wonderful as this panel and these discussions are, is not legal debate. It's not litigation strategy, not to say those are not important things. It is encouraging people to turn out and vote so that imperfect as the people that might get elected might be, they're better than what we have now, and we can enact some of the reforms that are necessary to get our democracy in place. So maybe we'll come back to that subject or not, but now I'll go back to our regular scheduled program. So yesterday actually was exactly 40 years to the day that I got the call that we had lost Bowers versus Hardwick, the case in which the Supreme Court by 5-4 denied that Americans, and particularly in that case, lesbian and gay Americans, have a right to private consensual sex even in our own homes. And it was a terrible blow. I was a young attorney at the time, as the 40 years might indicate. It was back in my hair days. And I, as a volunteer lawyer, wrote the essentially the movement organization's brief for several of the organizations, alongside the main brief that was filed by Michael Hardwick's lawyer, Larry Tribe, and so on. I think most of my colleagues, had always assumed we were going to win because we were so obviously right. Polling actually, despite the anti-gay sentiments of the time, was relatively on our side with regard to private consensual sex in the home. And I thought the system was going to work. And of course, when it didn't, I actually spent a couple days debating whether I should even stay a lawyer. Did I even believe in this system? Did I actually think it could work? You know, writing briefs, making arguments, trying to find reason, persuasion, etc., going to court, and so on. And after a couple days, I said to myself, the reason this happened is because not enough people know who we are. And if we do a better job of coming out, and not just coming out in a performative way, but telling our stories, engaging in conversations, building empathy and understanding, this kind of result would not happen. And I went out that day and bought a little pink triangle pin at the Oscar Wilde bookshop in the West Village near the Stonewall Inn, put it on, and swore I wouldn't take it off until we had overturned Hardwick. A mere 17 years later, I was able to do that. And so I tell that story because I want people to understand that terrible things do happen. The system doesn't always work. The courts misfunction. In this case, we have a captured court. We have a corrupted politics. We have obviously a toxic environment in our country. And trans people, of course, in the conversation we're having, have been a primary target, but by no means the only target. And yet, even in such a dark moment, our own history tells us, and our own lived experience and the lives of at least some of us on even this panel can show that we can change things, that we have power. The Supreme Court has an important word, but they don't have the last word. And it's our job to strategically and tenaciously and hopefully engage the work and the power and the persuasion and the vote and all the methods available to us, including, of course, litigation and legal strategy and legal teaching, to get our country back on track, to defend our democracy and to reinvigorate that democracy so that we don't get terrible decisions like the legislatures that put in place these kinds of sweeping discriminatory bans, as opposed to the more calibrated approach that the country was building to, as Shannon described so well. And so that we don't get people appointing these kinds of judges, and so that we don't have these kinds of judges. And that it's going to be hard. It's going to be long. It took us 17 years to overturn Hardwick. Now that seems like an eye blink, but I can tell you in our social life, people like me and Shannon spent those 17 years working long and hard, but it happened. And so we can make this change. What I think, the way I think that's specifically relevant to what my colleagues and friends have been discussing all day today, and what we're all really talking about, is we have tools at our disposal, and we have to get to work. We have to do the kind of work that Shannon was describing. We have to be telling our stories. We have to be helping people understand who trans people are, not in giant rhetorical poses and postures, not in alienating language, not in grand sweeping all or nothing performative politics, but in tenacious engagement at every level, including, most importantly, the conversation level, to change people's understanding and to reinforce their better impulses, to create a climate in which we also do the political and legal work we need to do to make sure that that climate gets what the climate creates and makes possible. And I know that sounds daunting and aspirational and maybe even vague or unsatisfying, but that actually is how change happens. And it is how we've done it before, as Shannon described. It is how we have been doing it on the question of how transgender people should be treated. Even today in this toxic environment, with this captured Supreme Court, with the all-out assault of the Republican Party and the Trump regime on trans people, even with all of that, even in this post-COVID lingering negativeness, even with all of that, the majority of Americans still support transgender people's inclusion and equality and right to certain protections and dignity, with some flashpoints and some questions and some things that they're not yet there. But even with all of that, there's a lot for us to build on, and we need to elevate that and engage that and then do the work I was just describing. Back in 1986, when we took that blow, we did the kind of storytelling and engagement and conversation and working in multiple arenas, politics, law, personal persuasion, recruiting allies, et cetera, that I just told about, elevating voices, elevating, connecting with shared values. But we also did certain specific things that my colleagues and the people on this panel are more the frontline experts on. We, as a litigation strategy matter, actually chose to avoid the federal courts for a period of time. We looked for other arenas and other fora in which we could make progress, be it state legislatures, be it localities, be it businesses, be it associations like the NCAAs and other things that are way out of my expertise, as well as at strategic and the right moments, deciding we could take this step into the federal court. We could go this place back again. But we chose our battles. We chose our arenas. We chose our timeline. And was that totally satisfying? Of course not. But did it work? Yes. We were actually able to overturn, for example, the Georgia so-called sodomy law, the one that Michael Hardwick had been arrested under and that the whole case in the Supreme Court had been premised on. We were able to overturn it in the through the process in Georgia, through the Georgia Supreme Court, before we were able to overturn so-called sodomy laws nationwide. We won in states like Montana. We won in a variety of arenas, et cetera, all of which was part of the building block strategic approach coupled with the engagement and the conversation and the persuasion and the politics that enabled us to move the country forward. And that is what we are going to do again. We have terrific organizations. We have brilliant, bright voices. I hope that people will bring to their voices the discipline of speaking in language that reaches the audience. You start by whom are you trying to persuade and work from there. You don't just throw language at them that they don't understand or don't agree with, or that force them from the get-go to make an all or nothing choice. You bring people along. And again, 17 years may sound like a kind of a long time, but it's a lot better than the alternative, which is not making change at all. And I really believe that that is what we're going to have to do. And again, not only on the question of the dignity and protection and inclusion of transgender people, but for our democracy itself.
Thank you so much, Evan. Before we turn to questions and conversation, and I hope we'll have some, I'll introduce our last speaker. Our last speaker is Chantove McNamara, who I've introduced already. I'll let you know that I think there's something very fitting about the transition at the end here, from someone who just talked about 40 years of experience to someone who, while already accomplished, is really in their first days on the tenure track. So love to hear what you have to tell us, Chan. Also, wouldn't mind hearing how Evan's story and Evan's tactics sit with a different generation raised with different experiences.
Sure. Thank you so much, Andrew, and thanks everyone for having me. I agree, I think, with everything that persons have said. I just wanted to touch on 2 points. I had some comments on the argument in the majority itself, and then I think a little bit of skepticism and disappointment with respect to the equal protection aspect of this case. The first part I wanted to touch on was just some of the logical flaws I see in Kavanaugh's argument. He does not at all speak to how these types of sports bans harm transgender persons. I think it's really disappointing to see the space devoted to trans folk being one line at the end, which is we shouldn't vilify trans folk, and a line in the middle where he says, some trans folk will be disappointed by this, but Title IX only guarantees equal opportunity. He devotes a lot of his time to speaking to all of the wonderful things that sports do for cis women and girls, and I think that's great. He does not speak to, one, how they're disadvantaged by trans exclusion. So since we've seen these anti-transgender inclusive sports bans come about, there have been so many cis women and girls who have had their wins contested. Just last year in Utah, we've seen politicians attack and vilify on social media actual cisgender high school students for seemingly looking too masculine and for with people assuming that they're trans when they're actually not. You know what would solve that? Trans inclusion. We wouldn't be vilifying cis women and girls if we allowed everyone in sports. Two, I think it was touched on in the first panel that this fairness argument that he's making, and sports being a zero-sum kind of environment, does not work in all contexts. This week, we have two Florida politicians contesting the inclusion of transgender women and girls in an Irish dancing competition. Now, I would love to understand what type of unfair advantage transgender persons could have in Irish dancing. Kavanaugh doesn't speak to the specifics of certain sports where there may or may not be advantages. He just assumes that there's this kind of permanent trans advantage. To move to the equal protection aspect of the case, which is where I really want to focus. I was so disappointed, quite frankly, that it was not addressed more forcefully. I think listening in at oral arguments, I really thought equal protection would play a bigger part in the final opinion. Justice Gorsuch was speaking at oral arguments to things like the history of discrimination against transgender people. I was so sure that he would speak about it in the final opinion. We didn't see it there. I think moving forward, though, Justice Thomas has flagged where he stood on heightened scrutiny for transgender people. So there's the benefit of now knowing that we have 3 people who believe that transgender people are undeserving or do not deserve heightened scrutiny. So there's that. We have clarity. To Evan's point on it's going to take a while and to speak to the public in language that they understand, I think both are really good points. Do I think that coming out and introducing trans lives to the wider public, ensuring that the wider cis public understands trans folk as trans folk, will help? I'm not so sure. I think if we look at what the political and kind of popular surveys are saying, I don't think the broader public is as transphobic as lawmakers are. There's somewhat of a disconnect. If we look at some of the kind of polling and surveys, we do see that people support, for the most part, a kind of base level transgender rights. It's the lawmakers who are ahead of the public in that domain.
Thank you so much, Shannon, and thank you to all of the speakers. I want to continue the conversation. We still have plenty of time. I have a couple of questions from the audience for this panel, and then a couple of other areas I might push for some speculation. The first question involved the curious absence of a discussion of animus in either Scarmetti or in this opinion. Given the constitutional pedigree of that argument, the success it's had in similar contexts, the court's failure to discuss it at all was notable to this person in the audience. They wanted to know first whether that is a plausible path in future litigation on these on trans and related issues. Is there some reason to think that door is just closed by the court's attitudes, or might that be a fruitful path? And second, if that is a fruitful path, are there particular cases or factual circumstances or scenarios in which a focus on animus might be helpful? So do any of the panelists have any thoughts on that?
I'll just say, hell yes, we intend on arguing that. We are arguing that. I think that's totally still open. I think it was not presented to the court in Scrimeti, so they didn't reach it, but they did say in the Scrimeti opinion that if it was based on animus or a pretext for discrimination, that would be a different constitutional story. So they left the door open very specifically. We certainly intend to press that argument in a number of different contexts. And if ever there was, reason to bring an animus-based claim, it's with this administration where they're just openly hostile. I mean, they're saying the quiet part out loud. They're literally saying and trying to get courts to establish and agree that disapproval of transgender people is a legitimate public interest, a legitimate governmental interest. So that issue is just squarely teed up. It's very squarely teed up in the transgender military ban. Say that's the place where it is most front and center. So yeah.
I'd just like to add that that issue was not argued in B.P.J. and Hecox. And here, I think we see a smart litigation strategy. It is much better to make the animus argument in contexts where the animus is very clear, because we have a Supreme Court that likes to stick its head in the sand on questions of explicit bigotry. We see that this term with the court's decision on the President Trump's very explicitly biased statements against Haitians in the TPS case. The court just says, well, we think the president actually had a good reason for this, which is immigration enforcement. So we're going to ignore all that. So this is an issue that I hope does not make it to the Supreme Court, because I think we would see that pattern continue where many of the justices want to say, well, sure, there's animus over here, but as long as there's some good reason, that good reason means we're going to disregard all the animus that motivated the policy. And we saw that, unfortunately, in Trump versus Hawaii, where the court made that move and tried to cabin animus doctrine. Lower courts, though, they can see it. They're calling it out all over the place, even since Scrimeti. And some of that is due to Shannon's really amazing work. But the Supreme Court is a dangerous forum for these arguments.
I think that's absolutely right. If I can jump in. Both
I'll just
Jessica
quickly
and
throw
Shannon,
in there that we do have like a federal district court opinion saying that the military ban was based on animus, which he called dripping with pretext, soaked in animus, and that was affirmed by the DC Circuit Court of Appeals. So I think that's probably the biggest case where it's that theory's moving forward.
I was going to say, it didn't strike me as important at oral argument, but now in light of TPS, it does. If you'll recall at oral argument, Justice Alito asked, are you accusing the cisgender women and girls who are against trans inclusion in sports of being bigots? Or he asked a question along the lines of, are you accusing these people of bigotry? And I think strategically and very smartly, whoever was responding said no. But now in light of TPS, I think it's a good thing that animus was not argued here because it could have been incredibly detrimental moving forward, as Jessica pointed out.
You know, as everybody on this panel knows, strategy has to be derived not only from the law and legal analysis and reason and good arguments, but also whom you're arguing to and who's going to make the decisions. And in at least a couple of these justices, if not the entire right-wing majority, you have right now judges who cannot see animus in the most blatant litany of racist and despicable rhetoric, as Justice Kagan documented in the TPS case, but can only see animus in anybody objecting to anybody's infringement on people they don't like, transgender people, gay people, immigrants, et cetera, et cetera. So it's not just whether you can prove animus and whether you have a legal hook for arguing animus, it's who do you have to get to agree to act on it, that there is animus. Which is why, again, strategy is going to have to consist of going outside the the box of legal analysis and even litigation strategy, and is going to have to be multifaceted for us to succeed, starting most importantly with reclaiming political power.
Well, the next question is a great follow-up to that because it asks a strategy context outside a question outside the context of litigation. One of our audience members wants to know, based on this ruling, and I'll say also based on all of your experiences, what advice do you have for the folks on the ground who are organizing to oppose the Washington State ballot initiative banning trans athlete participation? So that's a question about political and communication strategy.
I mean, just to let people know, just like meeting people where they are, trying to persuade people, acknowledging that we care about fairness in sports, and, making the point we don't need this extreme categorical ban. It goes too far, that there are, reasonable alternatives that can address fairness without just excluding everyone so harshly and categorically. Just trying to pull people along. I don't know. Evan, I'd be so curious if you have any thoughts on that.
I'm not obviously as much of an expert as you are, Shannon, but I would say I agree with what you just said. I think that we need to obviously try to keep it off the ballot. Maybe it's too late for that. You would know better. But I would say the approach to take would be, look, reasonable people can have different views on the exact right lines that ought to be drawn and so on, but to take that away from parents and school districts and go through your litany of sympathetic players and turn that into a political attack that sweeps everybody out and is not something we do in this state. Let's have the system we have, which is all these different players dealing with this in a reasonable case-by-case, fair way that addresses everybody's interests and acknowledges that people can disagree, but we still don't have to treat people as strangers to the law, aliens at our gate, et cetera, et cetera, et cetera. I think that's the way to talk about it. And of course, again, elevate genuine stories. Like the plaintiff, Becky Pepper Jackson in this case, and so on, and her parents, and so on, and really put the emphasis on that, not on some giant theoretical, alienating, languagey kind of framing that forces people to make an all or nothing choice on this particular line. I think that's the way to go. I believe actually, and Shannon, you know better. You may know better. There actually is polling showing that even people who are inclined toward restrictions and who have genuine concerns about girls and women participating and so on, then when asked, but who should make this decision, can kind of agree, well, it shouldn't be, some jackass state legislator in blah, 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 or it shouldn't be, an all or nothing sweeping, denying anybody of any nuance and any protection and any access. So I think that is the way to go. But I wouldn't do it, excuse me, in a completely abstract processy argument either. I would do it grounding it in human beings and families and participation that also acknowledges the participation interests of non-transgender kids and their parents and so on. I think there is a way to have that conversation that allows people to be kind of respectful across the line, no matter exactly where they fall on the regime that ought to be enacted.
Got plenty more to ask about substantive legal matters, and hopefully still have a few minutes for that. But two of the panelists suggested they wanted to talk about court reform, and I now have multiple questions on court reform. So let's talk about that directly for a minute. I thought this is a very well framed question from one of my students. Supreme Court reform would be wonderful in theory, but in reality, it's hard to imagine what reform could be achieved. What options of Supreme Court reform do the panelists believe are achievable in the next decade? What concrete steps need to be taken before tangible reform can be achieved? So, giving you the biggest picture questions, but in some ways the most important ones facing us now. Does anyone want to jump in on that?
I'm happy to, but Jessica raised it first, so I'm happy to let you go first if you'd like.
So I come at this from a different angle, which is my area of expertise is constitutional rights. And I watch the way that this court is eroding those rights. And I've been trying to work with this court, advancing ideas through legal scholarship, through amicus briefs, and I feel like we've come to a place where we're frustrated by the current court, and the solutions are out there. I have a colleague, a former colleague, Ganesh Siddharaman, who wrote a great article about court reform. I would recommend that in his work. One thing that seems that most people would agree on is term limits. Now, how to get that to happen politically, I'm going to leave that to other panelists to talk about. And that's not my bailiwick.
So I'll start by saying that, as I mentioned earlier, I, like others here, have done many Supreme Court cases. I've argued once in the court, and I've been on teams and litigated many, many cases. And I've won some important ones, and I have lost some important ones. And I haven't counted lately, but I may well have been on the losing side as many times as I was on the winning side. I never came out of the court in a case I lost and called for expanding the Supreme Court or challenging the legitimacy of the current composition of the court. I disagreed with their rulings. I argued that they got it wrong, et cetera, et cetera, et cetera. But what we have today is a captured and corrupted court. And it is captured as the product of a decades-long campaign by other advocates, like us, but with different political views, who mounted a sustained effort to literally capture the court, install justices who really should not be there, to get those justices on without the democratic legitimacy that even this counter-majoritarian body should have. And as these succession of just atrocious rulings, not just atrocious because they're wrong, but because they are really lawless. They really flout the plain language of the Constitution, as in the birthright case. They flout longstanding 100-year-old precedents, 80-year-old precedents, et cetera, without giving legitimate reason. They have played with the shadow doc. I mean, I could just go on and on. Because of that, it is time, as it has been in cyclical times in American history, the time for structural reforms that are needed. And to then answer specifically the question that your student asked, the Constitution actually makes very clear what the easiest and simplest and most direct and historically enacted remedy is, which is to expand the court. Now, we haven't done that in a while in the correct process, but we have certainly seen examples of players like Trump and McConnell reducing the number of justices when they didn't want to have President Obama, for example, make an appointment, and then rush through justices during an election cycle, just a few weeks before an election, while people were actually voting, having previously said we need to wait till the next election, et cetera, et cetera. So the system by which a significant number of the justices sit on this current court was corrupted. It is a captured court that is the product of a campaign, and it is time for the kind of cyclical structural reform that Americans have had to do, going back from changing the composition of the Senate and who elects the Senate to other measures, including changing the number of justices on the court. The Constitution gives that power to Congress. It doesn't require a constitutional amendment. It doesn't get reviewed by the Supreme Court. It is something that when we elect the right president and the right members of Congress, we can do. And it is the reform I would most talk about and call for as we head into the election, where I think we need to be saying to the American people, our democracy needs strengthening. It needs reinvigoration. We've done that before as Americans, the Reconstruction Amendment's on, and it's time for us to do it again.
Thank you. I'm
sorry, and I will just add, since Jessica talked about term limits, there are other measures that have been mentioned, which some people think might be easier or might be less controversial. There are reasons to argue for Supreme Court expansion. There are other reasons people are nervous about it, so they tend to go for certain other measures. And I would actually just say, I'm fine with all of them, but I do think it's Supreme Court expansion that is clearly constitutionally legitimate. It is clearly something that has happened before, and it is clearly something that would cure the hijacking of the court that we have seen as I just described, as opposed to some of the other measures that would over time rotate out some of the problem.
I'm going to ask you to, we'll finish off right about 12. I'm going to ask in two areas for some speculation about what comes next. One of them, I've been asked by reporters, by students, by questions from the audience, this more than anything else in the last 24 hours, which is what are the tea leaves from the tone, from the language, from the approach, from the votes? What are the tea leaves about the issues related to the rights of trans students and trans Americans generally in areas that were not doctrinally discussed here? So there are lots of cases coming down the pipeline in terms of student free speech, rights of parents, rights of teachers to use and not use pronouns, all sorts of issues about some equal protection issues that were unaddressed in other areas, students and employment and things like that. Moving back from the direct doctrinal implications of the decision, what do we get from this opinion and this set of opinions about what's coming in those areas, if anything?
Can I jump in here?
Yes.
So I want to start with we haven't mentioned enough that the court is also active on the emergency/shadow docket on trans issues. Specifically, we had the Mirabelli decision in California, forcing schools to out kids to their parents. And together with the Chiles or Child's case around the conversion therapy, one of the directions that I'm seeing appetite from the court is kids, parents, education, and the kind of the tool being First Amendment type speech rights and religious exemptions. So that's kind of what I wanted to add here.
And when you're politely saying you're seeing interest from the court, you're seeing conservative interest in pushing a set of parental rights and free speech rights and religion rights that are detrimental to the interests of trans Americans.
In whatever possible ways. So if they don't take it on the merits docket, they'll take it on the emergency docket. So my point is, I think we should pay as much attention as we're paying to the merits docket as we are on the shadow docket. And the military ban also had some important decisions on the shadow docket. So I'm just saying that we're seeing increased appetite to discriminate against trans people, but the ways are nuanced, and I think kids are remaining the focus. And kind of this conversion therapy case, I think we haven't paid enough attention to in general. Just how open they are to the idea that we should maybe change gay people and trans people, and that it's a speech issue to begin with. That is telling to me.
Anyone else want in on this?
I'll just say,
No, you go ahead. Go, Jessica.
And another really disappointing shadow docket order is a case called Trump versus Orr, which involved the Trump administration's decision to come in and change a 30-year policy of allowing transgender Americans to have passports that are consistent with their gender identities, which is so important to people in feeling safe and secure when they're traveling. The Trump administration came in on its first day, issued all of these executive orders with rank animus against transgender people, as the district judges are saying, dripping with animus. One of the things that it did was it said, you've got to have a passport now. You want a new passport, it's going to have your sex assigned at birth, which is really frightening. And this order, and it was preliminary, and so my hope is that the court will rethink this. It dismissed the discrimination arguments in two pithy sentences. The first one said, hey, your passport isn't the state trying to tell you who you are. It's just a record of a fact, like the country where you were born. Ignoring how harmful this is to put this on someone's identity document that they have to carry around when they want to leave the country. And then the second sentence, which goes to the animus point, said, hey, we are going to cite Trump versus Hawaii, which was the Muslim ban case where the court endorsed the first Trump administration's decision to enact a travel ban targeting Muslim majority countries, in which Trump admitted that the point was a Muslim ban. And the court said, well, but actually, you've laundered it now when we see some good reasons for it. So they cited Trump versus Hawaii to say, on this record, we don't see animus. And this, to me, was one of the most discouraging transgender rights opinions I've seen from the Supreme Court. It is so unfortunate that they would signal that these are their attitudes prematurely. I think when you do that, it's harder to change your mind when you're confronted with more facts and a better record. So I am very worried about that, but hopeful that these aren't the directions the court is going on birth certificates and identity documents.
Can I just say it's so ominous, it's so chilling. I just hope everyone, I think they're teetering on the brink of something very frightening. Just for all the reasons everyone has said, there's a deterioration in the language from Scrimeti, which very respectfully, even though I hated the decision, talked about transgender girls and boys in an appropriate way, to now the very troubling language in the B.P.J decision. I mean, they're trying, I think there's a lot of internal conflict about how to navigate acknowledging the reality of transgender people, talking about them. I mean, the more anyone who cares about people being treated humanely and decently and fairly can help create a collective atmosphere where they experience some pressure not to continue down this very bad path of acting as though it's okay, like Thomas just did in his dissent, to say that transgender people should just simply be, you know, denied any sort of dignity whatsoever. It's really, this is an important moment, I think, and people, all of us can do something to try to stop some of this slippage.
And one of the areas, this is my last question, one of the areas in which we're on the precipice, where resisting the change, fighting back, pushing back, holding it off, is arguably quite important, is an area that several of you have alluded to, but we've never kind of gotten predictions, calculations, academic reflection on, which is there are these cases now in some of the courts of appeals that are arguing that Title IX, in fact, bans the participation of trans individuals, in particular trans women, in women's sports, and several of them are proceeding apace in the courts. How likely is it that the court is going to grant one of those in the next few years, and how worried should we be about the result in that case?
I'll just say that at oral argument, the Supreme Court suggested it wanted to stay neutral on this. And the justices kept asking the advocates, if we rule this way, is it going to affect that other set of cases? And Justice Kavanaugh in particular didn't want to take a position on it. And so in terms of just sort of like what their real motivations are, I think they want to stay out of it. Now, in terms of the law, I am concerned about this holding / dicta / statement about Title IX and the definition of sex in Title IX obviously being biological sex, whatever that means, not gender identity, and what implications that might have in lower courts that are perhaps that we might have Trump judges who might run with that and say, okay, that means that you can't include transgender people. But I don't think the Supreme Court would go that far. I also, though, am not confident they would take the case to reverse it. So that's something I am worried about. I think that's the wrong way to interpret B.P.J. I don't think it does say anything about that context. I think good judges will see through that argument, but I can't predict what's going to happen.
On that very balanced note, I think we're done with the substance of our presentation. Does anyone want a last word or have anything else I should have asked them before I say our farewells? All right, seeing nothing, I really want to thank the panelists on both panels. A wonderful cross-section of participants, fascinating arguments. I learned a lot. I assume the audience did. The time went really fast. Thanks again, of course, to all the staff, faculty of Seattle University who've contributed to this event. particularly Karsten Kohut, Alicia Kahn, Nicole Jennings, Neil Griffith, and the entire tech team for everything they've done. Thank you for wonderful moderation, Kelly. Thank you to Dean Verona for supporting these events and for recruiting many of our panelists. I know that Dean Verona regrets that he can't be here today. So on behalf of the entire institution, my colleagues and everybody, thank you one more time. We look forward to talking to many of you over the next year and hopefully seeing some of you on the panel next year when we do our 5th annual rapid response webinar. Thanks, everybody.